Are you looking for professional training in forensic mental health?
My name is Dave DeMatteo. I am an associate professor of psychology and law at Drexel University. My expertise is broadly in the areas of law and psychology. I have joint training in law and psychology, so areas where law and psychology intersect, things like psychopathic personality disorder, drug-involved and mentally ill criminal offenders, diversion programs. The focus of the workshop is evidence presented by psychologists. So this will include our primary source of evidence, which is a report. And it will also include testimony, which of course is a source of evidence as well. As most of you know, testimony happens less frequently than a report. So we'll look at reports, we will look at testimony, and we're going to do this in criminal and civil contexts. So let's take a look at the current standards for admissibility. And in particular, I want you to be familiar with there's a trilogy of cases, and then there's another one that's added. So we'll start. I want you to be very familiar with these cases, and hopefully some of you are familiar with these cases already. So we have the Fry test, and then we've got the Daubert trilogy, Daubert, Joyner, and Kumo. There are three admissibility tests that we'll talk about. There's the Fry test, Daubert, and something called the relevancy test. One of the things that I want to caution you from doing is thinking that any jurisdiction has a very pure version of any of these tests. Before we look at this in the federal rules, how do you feel about the ultimate issue? So this is, should an expert witness offer testimony on the ultimate legal issue? So for example, competence to stand trial. What is the legal issue in a competence to stand trial hearing? Whether the person is competent to stand trial. Should you, as the expert, opine on the ultimate legal issue? Or should you maybe get real close to the ultimate issue but not quite say it? So how do you deal with a subpoena? What are some strategies for dealing with a subpoena? Well, here's a legal principle. This is our starting point, that sometimes we have to provide information that's necessary for courts to decide issues. Right? That's part of our civic duty, is if we get requests for information, that sometimes we have to provide that information. But we might want to start, if you get served with a subpoena, the first thing I do is, and this is a little steps that I go through, is I determine if the subpoena is valid. I would say probably a quarter of the subpoenas that I get are not valid. So here's the question. Once an expert has been designated, so the identity of the expert has been revealed to the other side, what work products or notes or reports are discoverable? This is what you might be required to provide to the other side. Every document created, relied upon, reviewed, or possessed in the course of your work on the case. This is exceptionally broad.
To learn more about Concept's professional training opportunities, visit us at concept-ce.com.